This will be dictation from test number video 9, State of Wisconsin versus Stephen Avery. That is where the material came from. If you'd like to see that, it's much slower on that video, about maybe 120, but I didn't time it. So if you'd like to go there and practice first and then come back here and do the 160, it's really up to you. But this will be read at 160. You ready? Let's begin. Let's write. The judge has told you that there is 4 charges. I'm very briefly going to talk about those 4 because I don't want to reiterate what the judge did, but there are 4 separate charges that the defendant is charged with. First-degree intentional homicide, mutilation of a corpse, felony in possession of a firearm, and false imprisonment. Now the judge instructed you in my job today in opening statement. Again, this isn't evidence, but it is a help for you. It's the cover, if you will. It's the roadmap. It's the overview to talk about the first legal concept that you as a jury has to understand, and that's the concept being called a party to the crime. The judge has told you that this can be satisfied either if the defendant committed an offense himself or if the defendant aided and abetted in the offense. Now the first 2 counts, the homicide and the mutilation of a corpse, are charged as a party to the crime, and you will learn at the conclusion of the case 6 weeks from now. If you fast forward 6 weeks from now, the jury instructions will tell you if the defendant committed any of those elements himself, or if the defendant aided and abetted in another in the commission of those offenses, that you can and should find him guilty. Now I can't stand up here and predict what the defense is going to bring into this case, what cross-examination they may encounter, or if they even choose to present any kind of defense, nor should I. That isn't my job. My job is to present our case, to present the physical evidence that we have developed, to present the witnesses that we have developed to prove our case. But just remember this concept when it comes time to deciding whether or not the defendant is guilty. The judge has told you about something called element of offense. The state has the burden of proof here. The defense has absolutely no burden to prove the case beyond a reasonable doubt. The judge explained to you already that means beyond a reasonable doubt, for which a reason can be given when considering all the evidence. Let me tell you what it is not, though. Burden of proof is not beyond all doubt. It's not 100%. And when we're dealing with the human justice system, you can't expect beyond all doubt or beyond a shadow of a doubt, or comments sometimes that we have heard about that. It's beyond a reasonable doubt for which a reason can be given. And I'm standing before you, members of the jury, telling you that I accept that burden. I will prove this case beyond a reasonable doubt, but we don't want you going into this case expecting 100% or beyond all doubt, because there are human factors and dynamics that go into these cases. Each case, the judge told you, has elements of those offenses. We're going to go through those in just a minute, but also each of the 4 charges should be considered separately. You cannot group them together and decide if he is guilty on all 4 or none. Each of the 4 counts are to be considered separately, and in fact there is separate evidence for all 4 of those counts. And finally, the defendant is presumed innocent, as Mr. Avery sits here today. Because you have not heard any evidence in this case, he is presumed by you, or should be presumed by you, to be innocent. However, and this is a big however, that presumption disappears at that very moment when the evidence in this case satisfies you beyond a reasonable doubt that he is guilty of that offense. That presumption disappears at the very moment that the evidence proves that he is guilty. Count 1. The judge instructed you has 2 counts, and why I'm telling you this and why I'm showing them on screen. or on a PowerPoint presentation is because there are serious crimes. In fact, the most serious crimes in the state of Wisconsin. The legal concepts aren't all that complex. We're talking about two things that we have to prove caused the death of somebody and did it intentionally. Nothing magic about that, nothing complex about that, and all of you should be able to understand that. The same thing with mutilation of a corpse. Just the two elements, that he mutilated a corpse and that he did so to conceal a crime that had been committed. You will hear evidence in this case about what the crime was that he was trying to conceal. The crime, as you may have already guessed, is the first-degree intentional homicide. Mr. Avery is also charged with felony in possession of a firearm. Again, two elements. The felony in possession of a firearm, that seems obvious. And number two, that sometime before November of 2005, he had been convicted of a felony. Now, the judge has told you that the second element is stipulated. Stipulation means that the facts are agreed to by the parties, that you can take that as already having been proved beyond a reasonable doubt that Mr. Avery has that felony conviction, and so it's just the first element of that offense that the state has to prove. Do you all understand that? All right. Now, false imprisonment has 5 separate elements to the offense. Those 5 elements are that he confined or restrained. Note that's in the disjunctive. He either confined or restrained Teresa Halbach intentionally without her consent. He knew he didn't have authority, and he knew he didn't have authority to confine or restrain Miss Halbach. All right, enough of the civics lesson. Let's talk about what the evidence is going to show on Monday, October the 31st. 2005, at approximately 2:45, the state intends to prove that the defendant restrained, murdered, and mutilated 25-year-old photographer named Teresa Halbach. We're going to prove to you what happened. We're going to prove to you who committed this crime. We're going to prove to you where it happened. We're going to prove to you specifically that it happened, and those will prove all of the elements of offense. What we are not going to prove to you, but the judge has already told you we don't have to, and in fact can't prove to you, is why. We can't prove the why in a case like this. That's called motive. The reason behind the killing. What was in Mr. Avery's mind when deciding to kill this person, this lovely young woman. I'm going to introduce to you somebody, this remarkable young woman who was 25 years of age. She was single. She was a freelance photographer. She had her own photography business that was, although in its infancy, was doing quite well. And I will remind you several times during this opening statement and throughout the trial, I will remind you that we're talking about a real person here, talking about somebody's daughter, somebody's sister, a lot of people's friend. Teresa Halbach had her whole life in front of her, and the evidence is going to show that on Halloween of 2005, that all ended at the hand of the defendant, Stephen Avery. My voice barely hung on to get that, but I was right on the money. That was 160 on the head. Some of the words that were in here that you might want to practice. See if I can get down to my little wrist. Reiterate, first degree, homicide, aided and abetted, opening statement, mutilation, party to the crime, cross-examination, beyond a shadow of a doubt, dynamics, separately, presumption, PowerPoint, I made that up, P-O-U-R-P, that's my PowerPoint. Mutilation of a corpse, I just do mutilation, corpse. Stipulation, restrained, confined, years of age, photography, photographer, Halloween, infancy, motor, remind, and Stephen Avery. So I brief a lot of mine. I've got stipulations. I got a lot of briefs. So good luck and happy practicing.